Leading researchers continue to caution against the dangers inherent in the expert evidence about the how and when of the DNA transfer. There is a broad acknowledgement that a perpetrator of a crime could bring traces of another individual into a crime scene and deposit these traces via secondary transfer. This could falsely link someone to the scene of the crime and could lead analysts and other medicological professionals to falsely conclude that DNA left on an object is a result of direct contact, especially for a removable object such as a knife sheath. Movable object. Judicial response to risks of secondary transfer. Alongside a growing awareness of the risks of secondary transfer, the reaction of Canadian courts has been varied. That said, in a number of promising decisions, courts have shown an acute awareness of these risks. On one front, courts have continually acknowledged the need for rigid adherence to principles governing expert evidence. Expert evidence is both immensely important to legal adjudication and equally dangerous. The concern is where an expert witness, veiled in their authority and bolstered by often superior knowledge, provides evidence cloaked under the mystique of science. It may be perceived as being virtually infallible and having more weight than it deserves. History teaches us of the dangers of expert evidence. In the worst of cases, dubious expert evidence has contributed to wrongful convictions. In recent years, Canadian courts have been very careful in scrutinizing the reliability of DNA evidence in circumstantial cases. It has been found that DNA evidence, powerful evidence that the person whose DNA is on the object was in contact with the object. However, the connection of the accused with the crime will depend on the existence of other evidence capable of establishing contact with the object at the relevant time and place. And R.B. Grayson, the accused, was charged with the theft of a vehicle, which was found abandoned 2 days later. The accused's DNA was found on the baklava located in the vehicle. The ONCA overturned his conviction and entered an acquittal, having applied the 2-stage test set out in DDT. The court observed that the Crown cannot point to any evidence that makes the inference that the appellant was in contact with the garment in connection with the theft more likely than the inference that he was in contact with the baklava at some other time. Evidence of the accused's DNA on the baklava only demonstrates that he likely wore the garment at some point in time. In R.V. McGinn, the accused was charged with offenses stemming from an armed robbery of a liquor store. The case was based on DNA located on a neck warmer located in a stolen car later that night. In reaching his decision, Justice Lee considered expert evidence related to the possibility of DNA transfer between persons and the possibility that an individual could wear an item and leave no DNA at all. Justice Lee found that this clearly establishes the limitations of that evidence. He found that the DNA evidence is only at some point in time the accused's DNA came in contact. Courts have been cautious about scrutinizing the permissible scope of expert evidence related to secondary DNA transfer and are beginning to appreciate the significance of this distinction. For example, in R.V. Sabry, a swab taken from the complainant's breast contained the accused's DNA profile. DNA evidence was central to the case. The trial judge found that the Crown had not advanced sufficient evidence to rebut the possibility of secondary transfer. While the expert had concluded that some transference scenarios were more likely than others, her conclusion seemed to be grounded in common sense rather than a result of scientific studies or testing. Absent more information about the scientific foundation of her conclusions, I find myself without any real ability to assess them and am cautious about placing any weight upon them. I am also mindful that Mrs. Shaker was qualified as an expert in comparison and analysis of DNA. She was not qualified as an expert in transference of DNA. It is critical that an expert to be confined to giving evidence only in those areas that they have properly qualified. I find that Ms. Shaker's evidence about transference outside of her expertise, that was beautiful. Whatever judge said that. In acquitting the accused, the trial judge concluded that while she accepted that DNA was found on the complainant's left breast, I am not sure of how it got there,